Court of Appeals of Tennessee is now in session.
Thank you, Ms. Dempsey, and thanks to both counsel for participating in this oral argument, which we are live streaming for public viewing. We will conduct the hearing today in the same manner as if all of us were in the courtroom together. Each side has 15 minutes, and I understand the appellant has already reserved some of your time. Unless there are any announcements, I'll ask Ms. Dempsey to call the case.
Gregory Charles Hoppe versus Susan Lynn Hoppe.
Ms. Pulley, you have the floor.
Thank you, Your Honor.
One quick question. The clerk of the court just sent us notification of the bankruptcy discharge of Ms. Susan Hoppe, and does that have any effect on these proceedings?
Your Honor, I didn't even know she was in bankruptcy, so.
I didn't either. I don't believe it has any effect on these proceedings.
Very good. Just wanted to make sure that none of us got in trouble with the federal court. All right, please proceed.
Thank you, Your Honor. This is a post-divorce modification of the residential schedule in a permanent parenting plan. Mr. Hoppe filed for divorce in 2014, and that was when the mother began her crusade against the father, making the false allegations of sexual abuse against, at the time, the minor son. The last allegation, which brought rise to the trial that we're here on today, involved both of the minor children. Because we had so many issues, Your Honor, I only want to focus on the two issues that I think were the most important because I have such limited time. The first issue I would like to discuss is that the trial court erred in not finding that mother's violation of the court orders were a material change of circumstances, and that the current parenting plan is no longer in the best interest of the minor children. We relied heavily on the Avery case, which is a 2018 case. And in that case, the facts were very similar to this case, in such that the mother continued to make false allegations of sexual abuse against the father towards the child. The court held in that hearing at that trial, the court held that there was a material change of circumstances based on the fact that she was continuing to make false allegations. That was a material change of circumstances. That case also held that you could modify a parenting plan based on a refusal of the parent to abide by the court orders. Your Honor, in this case before you today, this mother admitted on the stand to 15 violations of court orders. Not only the parenting plan orders, but subsequent orders that she was placed under after she made the last allegation of sexual abuse by the father. At the hearing, the DCS worker testified that since 2014, the mother had made 5 allegations of sex abuse against the father with these children. 3 of those resulted in forensic evaluations with the children. Every time unfounded, there has been zero evidence that these children have been sexually abused. The most recent allegation—
And those all occurred, you're saying, since the entry of the final decree?
Yes, Your Honor.
So how many total reports happened after entry of the final decree?
4 after entry, I'm sorry. 4, and to be honest, she's filed yet another one since the this last hearing. So now we're up to 6. She's had 6.
Is that part of the record, counsel?
No, Your Honor. No, Your Honor.
That's not before this court on these issues, correct?
Correct, Your Honor.
Thank you.
So yes, since the final decree, there have been 4. So, but it started upon him, the father, filing the original divorce. Now, the last one that brought us here, these children were seeing Janie Berryman. They were in therapy. At no point during the trial was Janie Berryman, Dr. Berryman, called into court to testify, yes, this is what's going on. So here we have yet again false allegations with nothing supporting it. The next issue I want to discuss would be the fact that the judge relied upon the 366112, that the parent alleging abuse, that she did this in good faith. Your Honor, in Cone, in NRA SC-B, in AG, the courts address a good faith and reasonable belief requirement. And based on those cases, it is our position that the court should not have used a subjective approach when making that decision. The court, in our opinion, should have taken an objective approach based on the multiple false reports made by the mother and her admitted refusal to adhere to these court orders. She literally testified in court that she still believes the father has sexually abused these kids. She will not turn loose of that thought process. There have been multiple therapists that she has seen, and as of today, she still believes this. At the trial, the mother admitted that she still believes the father is sexually abusing the children, and regardless of what the proof shows. That was in volume 2, page 229, lines 7 through 14 of the trial transcript. She has sent, I've already told you that part, I apologize for that. So it's our belief that the judge should have taken an objective approach about the continual allegations of the sex abuse by the father, and not a subjective approach. There's been no evidence presented, there's been no evidence found that anything inappropriate has taken place with these children. And in the initial parenting plan, Your Honor, they agreed that the father would be the primary residential parent. So that was an agreed parenting plan. It wasn't an ordered parenting plan. The mother has been seeing mental health professionals since the entry of the final decree. They appear to not be able to get anywhere with trying to get her to understand their false allegations. It's not happening. There's no proof. I want to address the fact that the trial court modified the parenting plan, even though it did not find a material change had occurred. And by that, the court ordered that this child, the son, continue with therapy without any reason why he should. The original parenting plan stated he was to be in therapy to help him cope with the divorce of the parents. That has long since been done. We entered into an agreed order in 2017 that allowed for a certain number of additional therapy sessions for both children. The mother admitted at trial that she violated that order. She took the children to therapy more than she had agreed to. It's our position that these children, they're over-sexualized. They do not need to continually be discussing sex abuse. They do not need to continually be subjected to therapy. They need to be able to be children and not have to undergo forensic evaluations, not have to be pulled out of class at the school to discuss if the father's touching them inappropriately. So our position is, Your Honors, that the court should have found there was a material change of circumstances based on the fact that there's been multiple false allegations. The mother refuses to adhere to orders of this court, and that she needs supervised visitation at the least until she gets the mental health that she needs to move past this refusal to believe that there's nothing going on between the father and the minor children. Thank you.
Ms. Pulley, let me ask you, you said the trial court did not make a finding of substantial and material change of circumstances, but the court did modify the parenting plan. In what aspect are you appealing that?
That they did not make the court did not find there was a material change in circumstances, and they should not have ordered more therapy with a new therapist, that the parenting plan should have been left as it was.
But is that considered a change of the parenting plan, or just supervision by the trial court of a child's needs, medical and psychological needs? I may be splitting hairs, but
I believe it is a change in the parenting plan, as there was no basis for the judge to order more therapy. There was none, no evidence, no proof, nothing that this child needs to continue with therapy.
Well, let me ask you this question. The provision that the parties agreed to about therapy sessions for the children, did that appear in the parenting plan, or was that somewhere else in the divorce papers?
That was when there was another allegation of sex abuse, Your Honor, we filed another petition back in 16. And in order to resolve that, we entered into an agreed order that agreed to the minor children undergoing a specific number of sessions, a specific number of days each week. And then after that, it was to stop.
Was the trial court amending that agreed order or making an amendment in the permanent parenting plan?
Make an amendment in the permanent parenting plan.
all right. Thank you, Ms. Pulley. I bet we'll have more questions of you and Ms. Hood on that very subject. Ms. Hood.
Thank you, Your Honors. I'm Dina Hood, and I do represent the appellant in this matter. I want to address, before I forget, just specifically, since we've been on Your Honor's questions about what the trial court did. The trial court took great pain to make sure that he was following the parenting plan. You'll see when he's announcing his decision, they discuss this in detail. And particularly in trial record volume 4, page 466, is where the court discusses this. No, I'm sorry. That is where the parenting plan itself says, and this is in the original parenting plan, that it states one of the goals of therapy is to remain psychologically healthy in spite of his parents' history of contentious relationships with each other. And I'm sorry, as I write this, I think that was Judge Binkley's words. What the court did is looked at a specific portion of the parenting plan where the goal of therapy was to help the child to be able to deal with the parents' contentious relationship. And so the court didn't change anything of the parenting plan, but continued that therapy with the child's current therapist. The parenting plan had the therapist as Paris Goodyear Brown, but the parties had since did an agreed order that the child would see, I believe, Jamie Berryman. So the court just continued that. With respect to, if I can go to start my issues, I want to tell the court that I believe that this is a terribly sad case, but one in which Ms. Hoppe's rights were completely trampled on throughout this process. And the testimony is that her son made disclosures of sexual abuse to her. The testimony was that two professionals, both her psychiatrist, Dr. David McMillan, and her attorney, told her to record these statements because no one will believe her. At their advice, she did just that and recorded those statements. She took the child to Dr. Berryman. It was Dr. Berryman who reported to DCS the allegations. She filed an order of protection, which
And
was
was this a recording that took place in 2017 or
2018,
2018?
Your Honor. Yes, Your Honor.
So that was late 2018.
Yes, Your Honor. November 20th of 2018, right?
Had you made any allegations or reports of sexual abuse of the child prior to that, but after the entry of the final decree?
Well, I was not her trial attorney, but in reading the trial transcript, I don't recall any evidence that she did. And I would say this as well.
So you would dispute the contention that there were 4 reports of sexual abuse since the entry of the final decree?
I don't dispute what Ms. Pulley says. I dispute as to who made those referrals. They're supposed to be confidential by law. I would dispute whether it is absolutely attributable to mother or not. I would also dispute very strongly that she violated any court orders by one, recording her child. There was no court order telling her not to record a statement of the child when she did, and she acted on 2 professionals telling her to do so. There was no court order saying that she should not report allegations of abuse. And there is a tape recording of the child making allegations. So on November 20th, she filed an order of protection, which was entered, and the court awarded her custody on an ex parte basis and set the order of protection for December 3rd of that year. The next day, father filed in the 4th Circuit a restraining order, restraining her from asking the court ex parte to restrain mother from having any contact with the children and to place with him. The 4th Circuit, without a hearing, issued that restraining order, said that, quote, there was probable cause, which is not the standard that is required for a restraining order under 65.03.
What relief can we grant your client on that? I mean, isn't that expired?
Yeah,
It has expired. And the
That's
reason
that's not before us, is it? I'm getting a little confused.
well, it's the history of this case, and it does factor into how Judge.
No, I think we ought to focus on Judge Binkley's hearings, the evidence before Judge Binkley, his ruling, and the issues raised on appeal. And I don't see how anything from the 4th Circuit is before us.
I will rely on my brief and move forward with the hearing with Judge Binkley, because there's a lot I want to say about that as well.
Sure.
First, Your Honors, it's important to determine what the standard of proof is for that hearing. It's our position that a material change of circumstances is not the appropriate standard of proof for that particular hearing. Under 366405A, when a party files a petition to modify a parenting plan, they are required to file their proposed plan. In this particular case, the father did not do so. The only thing that we have in his petition is that he sought that the mother's visitation would be suspended indefinitely. There was no proposed plan saying that he wanted to modify in any other way than suspension. At trial, he testified that he wanted to have supervised visits. When that is the relief you're seeking, the appropriate standard is under 366301, and it's also through Rudd v. Rudd. The court in Rudd v. Rudd and Rudd v. Rudd 2, if you're, let me just take just a moment of the details. In that particular case, the father was found to have sexually fondled his daughter. As a result, the trial court suspended all visitation. The father appealed, and the Rudd court on Rudd v. Rudd 1 sent it back to the trial court saying that in order to suspend visitation, you have to do 4 things. 1, you have to make specific findings. 2, on definite evidence. 3, that the visitation would be harmful to the child. And if you do that, then you have to make a finding that there's a least restrictive alternative. They sent it back in Rudd. They had some more proof, and the judge again said he has sexually abused the child. That's harmful to the child. So therefore, I'm not having any visitation. Well, Rudd v. Rudd 2 was issued by then appellate judge, Judge Kirby. And I want to read because it is so important and critical on the analysis of what the appropriate standard of proof that Judge Binkley had to look. And here's what she says. Because of the legal and psychological significance of a parent's visitation rights, persons seeking to restrict or eliminate visitation must demonstrate that there is probable cause that a child will be risked if visitation is permitted. The Tennessee Supreme Court requires that proof must be definite, and that Tennessee Annocoded 366301 requires that the proof demonstrate that visitation is likely to endanger the physical and emotional health. These evidentiary standards have effectively created a presumption against severely circumscribing or denying visitation to non-custodial parents. Such drastic measures are only appropriate when arrangements less detrimental to the parent-child relationship are not available or workable as a practical matter. The Rudd 2 court said to the trial court, "We've told you once how to do this. You didn't make these findings. Now we're going to send it back and give it to a different judge." It's not enough in that case to say, and the Court of Appeals admitted, we are accepting that he has sexually fondled the child. That was not the issue. That's not enough. You have to make the nexus to the child that behavior is that there's specific harm, detrimental, that visitation will result in a specific harm. Now, in this particular case, there is no doubt that father is attempting to, 1, either terminate indefinitely her parenting time, or 2, trying to suspend it indefinitely, or have it supervised indefinitely. Judge Binkley, and I've got this in my brief, what he said about this. He acknowledged this, that he had to apply the Rudd factors. He acknowledged that and he said, with all due respect to his prior colleagues didn't, that the Rudd factors had to be acknowledged. And the proof, Your Honors, about these children, they're doing great. Dad said they were fantastic. The children were returned to him on November 21st of 2018. His testimony when they returned was that they were fine. The next day, they were back to normal. There's a lot of testimony about how wonderful, in fact, the children are doing, how they're excelling in school, they're excelling in their extracurriculars. He doesn't believe that they're in need of counseling. They're doing so well. So there is just absolutely no nexus whatsoever. And it's critical in these type of cases to understand what the appropriate standard is. Now, if Your Honors disagree and say that a material change of circumstance is the appropriate, then what I wanted to tell you is the judge did consider, Ms. Pulley talked about the 15 violations. The judge did consider them, and he made rulings of saying that they were not substantial changes that adversely affected the health of the children. For instance, he said that the trial court stated, and understand that appellate's point that having the children go to counseling in excess of the 36 sessions as the agreed order provided is a technical violation. However, the court didn't think that additional therapy for the children was harmful. There was an incident where LH, the minor daughter, sat on the mother's lap at an event. That's a technical violation of an order. However, the appellant testified that she didn't have the heart to tell her daughter that she couldn't sit on her lap, and the trial court found that that was not material and it didn't negatively impact the children. So the court went through all of these violations and made those analyses and said, these are not material changes in circumstances. The appellant, even though didn't raise here in her brief, stated that the court ignored the testimony of Dr. Kenner. I've put in my brief 3 pages where the court went into great detail of the testimony of Dr. Kenner. The court reviewed it, just didn't accept it. The court said, I'm not saying he's not credible. I'm just not relying on it. I don't accept this. On behalf of the appellant, the allegation was made today that my client has these mental health that the counseling is not helping. It's not able to work. And I'd like to say that I do believe, absolutely unintentional, that there were many statements that's not supported in the record that you heard today, and that being one of them. Dr. Kenner, who was the appellant's expert, testified that she's doing much better. He attributed it to a change in medication. Her counselor, Dr. McMillan, said that she was doing wonderfully and testified on her behalf about the progress that she's made. Finally, I see I only have a minute, Your Honor. If I could go to just quickly on the issue of attorney fees. My client, after Judge Binkley's hearing, he restored the permanent parenting plan. And the only thing that he did is, under the provision with the child to therapy, that the goal of therapy was to help the child with parents' contention. That's the only thing he changed. Clearly, by any definition, my client is the prevailing party. Judge Binkley denied her attorney fees, I believe, on the misinterpretation of 36.5.103C that allows for attorney fees under the statutory basis, because he believed that it meant she had to file a lawsuit to get it and not defend. And then finally, I cited to Your Honor the Supreme Court case where Judge Bivens talks in Epperback versus Epperback. When you have a marital dissolution agreement and there's an enforcement clause, which we have here, it is that the courts shall award attorney fees to the prevailing party. The court, of course, is still in charge of what is a reasonable fee.
Thank you very much. We'll hear rebuttal.
Thank you.
Your Honor, as far as the attorney's fees, it's my recollection that there was no provision in the parenting plan for the attorney's fees. I could be wrong, but I remember that being an issue, that it was not in there. I want to address the Rudd case versus the Avery case. The Rudd case is a 2011 case, Your Honors. Avery is a 2018 case. And in that case, the father was absolutely seeking for the mother to have supervised visitation. At the trial, we did specify that in the alternative, let the mother have supervised visits until she gets her mental health issues under control. Dr. Chang, which was her psychiatrist, testified he had no idea about any of these other issues going on. She had not made him aware of the Dr. Trey Monroe deposition like she was supposed to. She had not provided him with copies of Dr. Freeman's Rule 35 evaluation on all of the parties, which was part of the parenting plan. He had no idea. He relied, and he testified to this, he relied solely on what the mother told him. He didn't know about the fact that she was violating all of these court orders. And I know that the trial judge said that they're technical. I don't know what a technical violation of a court order means. You've either violated the court order or you did not. She admitted she violated them. She admitted she had not been paying her child support. She admitted that she did not provide the documents to her therapist, Dr. Chang, psychiatrist, that she was supposed to. These were things that she admitted openly on the stand. And I do think that they have a bearing on the children. I think that if the mom is not mentally stable, that it will affect the children. The judge during the trial made multiple references to his concern about her mental health. He even said he thinks that's why she doesn't understand the orders, because, and he questioned it, her mental health, her abilities. Yes, she works. I don't know if she's still working now. At the trial, I think she had quit her job and was trying to get on working part-time. I think in this case, it's our position, Your Honors, that 366101A2C is the controlling statute. And in that statute, it states, if the issue before the court is a modification of the court's prior decree to a residential parenting schedule, then the petitioner must prove by a preponderance of the evidence a material change of circumstances affecting the child's best interest. There is not a requirement of a showing of substantial risk of harm to the children. And you can rely on the failure of the parent to adhere to the parenting plan. Avery addressed that absolutely and stated that failure to adhere to the orders is a cause to modify. And it also stated that repeated false allegations was sufficient to modify the parenting plan. That's our position here today, Your Honor. Thank you.
All right, thank you. Thank you both. Any further questions from the panel? Hearing none, we will take this matter under advisement. Ms. Dempsey? You're muted, Ms. Dempsey, you're muted.
This honorable court is in recess until 11 a.m.
Thank you.
Thank you.
Thank you.